to get a sense of what the challenges that we have at senior management level are. But what has occurred in the year as we try to fill senior management vacancies? And I think we've done our best to attract and recruit the best talent there is in the market, requirements permitting. And we've brought a good number of talented, dedicated, and patriotic South Africans who have joined the fold of the senior management of the department. And we're very convinced that using that analogy that we gave at the beginning of the year, that we were not necessarily going to promise to challenge for the championship. We think we're ready in the new year to challenge for the championship, not just to avoid relegation, but to challenge for the championship. And we are not deluded and we're not oblivious to the challenges but we think we are up to the task. I thank you, Chair.
Thank you very much, DG, and to your team. As I have said, this is a beginning of quite a few meetings that we are going to have with you, with yourselves, based on the visits that we have had, and we are going to continue to have them as part of our oversight visits. If I may just ask you one issue, DG, quickly. Since you took over as a DG, how many people did you take through the consequence management processes, except those that were charged for corruption and resigned, just for incompetence and other things?
Just from the top of my head, I know of one case at a senior management level that is currently running, and we hope to conclude it in the next before the end of April. We hope to have it concluded. It also has some hallmarks of performance related to it. But I know, Chair, you did raise this with me previously, that beyond charging people for corruption and impropriety, you would want to see us dealing with having consequence management for poor performance. And what I'm glad of is that the senior management of the department, the very senior management of the department, is sitting with me in this room, but also is joining online. And so they know what is expected of us as this cohort when we appear before you.
No, thank you very much. I think one issue that we just have to put it to your attention, that this process, we are required to report to the House about the oversight visits and what we have done. So this is part of that process, so that we can have a report to the House in the next quarter. And the issue that was raised by Honorable Janji and Honorable Nevot Dragens, it's going to form part of the report to the House. We are going to ask the House to engage the Public Service Commission. We do think that those of us who have served in this committee before, and I think even Honorable Swart and other members, most of what we are hearing, we have heard it before. Now, as representatives of the people, one of the problems that our people are faced with, it's a collapsing office of the master. So we can talk about all of these things that we are changing, we are turning things around, we are changing this, we are changing that. But at the core face of what is facing our people, it's a dysfunctional system. And time has come that as the representatives of the people, we can no longer just be satisfied with administrative reports, when impact on the ground is different from what we are hearing from the administrative reports. We can no longer accept it, because we must be able to say to our people, indeed, we have an understanding of what are the challenges in the Department of Justice and Correctional Services. We have to say to our people, we have a department that is fit for purpose, or it is not fit for purpose. For instance, if you have, for some time when there was no BAC, what kind of a department is that? When your own risk assessment identified this issue in 2018, 2019. And we're just talking about just one issue. And you know that when we deal with the department as a whole, there are a lot of other issues. Even when we met with the judiciary in the various provinces, there are quite a number of challenges that our people are faced with from the department. So we cannot really say we are just going to trust what you are telling us. I think we have reached a stage, it's not a reflection on you as individuals, but your predecessors for many years we have been promised many turnarounds. We have been promised many turnarounds. Now, the minister said at some point the vacancy rate was 28%. You are going to bring it down to 17%. And I got a sense that in a way you are self-satisfied as an achievement that you have brought it from 28 to 17. But based on whose standards? Because the public service says 10% and below. Even 17% is way too high. It's way too high. Unacceptably high. So on our side, we just want to let you know that we are going to have a much more detailed terms of reference that we are going to develop as a committee, so that when a resolution is put before the House for the Public Service Commission to come and assist, it is based on those detailed resolutions. This is meant to strengthen the capacity of the state. This is meant to ensure that our people are served properly by our government. It's not a vote of no confidence on anyone. We understand that most of you are new in this department. You have just been appointed to senior management, but we are interested and much more interested in systems, in improving the systems that will outlive all of us. We don't want systems that are based on the incumbents. If they leave, everything collapses. We want to ensure that we work with yourselves to strengthen the state as a whole. Honorable Janji raised an important point that the vacancy rate has been high since 2011. It's now 2022. and we are happy that it's going to be 17%. So that is not a department that on its own, we can say it can turn the corner in a shortest period of time. In fact, my view is that with all your best endeavors, it can take close to 10 years at the rate at which we are going. And our people are not ready to wait for 10 years. They are not ready. They want a change now. So we have an obligation ourselves to ensure that we lend a hand to ensure that this department is turned around urgently. So we are still going to also go back to our records of this meeting and to check some of the issues that members raised as further information that was required from yourselves. We will be writing to you to request that particular information, but there are other issues that we are still going to come back to you to raise. For instance, it will be important that you can start preparing for, start now engaging the Department of Public Works. There is a disaster waiting to happen at Pambridge, a magistrate court. And the judiciary and everybody there is concerned that that court can collapse at any time. So these are the challenges that we are concerned, that keeps us awake at night. And we think that you have the right intentions, you have the right skills, but we need a faster pace than what we are getting. Thank you very much, members. The meeting is adjourned. Thank you very much, DG, and to your team. I'm not sure whether.
Thank you very much.
Thank you very much. I'm not sure whether Dr. Lutz is still around.
Good afternoon, Chair. I am present in the meeting.
Thank you very much. Can we now go through the Cannabis bill? Thank you very much, Dr. Lutz. Can you take us through?
Recording stopped.
Thank you, Chair. I will do so. I'm going to try my best to represent
Recording in progress.
Advocate Roberts as best as I can, and hopefully I do a good job at it. The proposed amended bill was emailed to members, I think, yesterday. My apologies for the short turnaround time, but we were quite pressed for time. The first thing members will see in the proposed amendments is to the long title of the bill, and that's where we go into the area of having to seek permission from the House to expand the scope of the bill. And I think
Sorry, Dr. Lutz, I think it's something that I should have tried to address before. Members, can I suggest that maybe when 3 o'clock comes, we use the other devices to join the House, and we ensure that at least we finish this thing today, so that it is published as we agreed for public comments. I think after today, our next week it's upside down. It will be difficult to meet, and if we don't give a go ahead today or this term, then it will be difficult to take advantage of that 2 weeks. In fact, that recess that will allow for public participation. So I'm asking for members' indulgence. If we can use other devices to join in the House, is that in order?
Yes, Chair. We agree. Thank you.
Thank you very much. Is there anyone who disagrees? None. Yes, thank you. Can you proceed, Dr. Lutz?
Thank you, Chair. I'll also try from my side to be as concise and to the point as possible to
Yeah, that
save
will
time.
that will be appreciated.
I will do so. So, Chair, just to highlight, I think Ms. Silkston has prepared an interim report that we will present to the committee after I've highlighted the amendments, which will address these additions of commercialization, cultivation, religious exemptions, and so forth, for permission then to take the process further. Then I'm going to skip to members have seen most of the technical amendments and the exclusions, which Advocate Roberts have already addressed. So I'm just going to jump to the pertinent points that we were asked to deal with. One such was in the cannabis definition, where debates and deliberations focused on the 0.2% THC per volume. In our technical discussion with Advocate Roberts, we figured out that what's happening here with that 0.2% and the 2%, the suggested amendment, it's not, it should not be seen as an arbitrary hindrance, but rather as a definition that guides the bill in explaining what falls inside and what falls outside certain scopes of certain regulatory provisions. So by upping that percentage to more than 2%, we are actually giving a broader scope of private use protection as per the Constitutional Court judgment than we would if it was 0.2. So there is a clear rationale behind the proposed 2% in giving as much private privacy protection as possible while also regulating certain offences. And then here within option 2, where option 1 that he previously presented was a very basic form of that, not looking at the percentage, but just the concentration. We're proposing an option 2 here for the committee to consider to give us a mandate to publish, Chair, with just small exceptions here with the C1, those provisions that will be the exceptions to the 2-point sentence where offences are regulated, but with the aim of protecting children. Or here with the further provisions here also with the protection of adult persons who do not consent to the smoking or the use of cannabis in their presence. So the exceptions here are with specific protection aims and to balance that right of the child and other people's personal preferences with that right to private use then as per the Constitutional Court's judgment. Chair, so I would like to put this option 2 to the committee to get guidance whether we can use this in this extended version to put to in the bill for public comment. Thank you, Chair.
Do you agree with option 2, members?
Yep, Chairperson.
Honorable Jala?
Thank you very much, Chair. I think to me, I'm fine with option 2.
Thank you very much, Honorable Jala. Any other hand? I think we agree. Let's move.
Thank you, Chair. We will then do so. Then I'm going to jump down to just to TH here with immature cannabis. That centimeter reflection with immature cannabis has been deleted to just say, but excludes a seedling. And then with the definition of seedling, the centimeters have been adjusted. So Advocate Roberts just did a adjustment there also to include such expansion. And then he previously did mention the amendment with regard to smoke to also include in its ambit then the NL and XL of vapor and so forth to cater for our current reality. Then with the definition of THC, during our technical discussions, we looked at that definition. And for me personally, it was quite scary because I'm not a scientist. And we asked that it be made more accessible so that people who pick up the bill and don't have that scientific background or any specific knowledge of cannabis composition would also understand what that THC definition means. And the proposal that we put to the committee is the following. So we keep to an extent here just the technical scientific part, but then in brackets explain what it is. So with that version, which I can't express or pronounce, it means a non-psychoactive chemical that may be converted, and that one means a psychoactive chemical. But what we also then picked up in our discussions is that it may, for completion's sake, be necessary to not only define THC, but THCA. And to then say that the THC is a psychoactive chemical that includes THCA, and then to define THCA as a non-psychoactive chemical that may be converted to the THC, just to break down that difference and to make it more accessible as a definition to the general public that don't have the specialized knowledge that would require. So Chairperson, I would like to propose the inclusion of option 2 as the broader version, the more expansive definition for inclusion in the bill for public comment. Thank you, Chair.
Thank you very much, honorable members. Option 2. Honorable Jailer.
Option 2, Chair.
Option 2. Is there anyone who disagrees? None. We agree with option 2.
Thank you, Chair. Then I'm going to move on to the commercialization clause, where the issue here was to tread that fine line within not letting the bill be seen as an obstacle towards future commercialization, while also adhering to the fact that there are certain international agreements that South Africa's party to that would require us to at least give some guidelines in this bill without treading on the mandate of other departments and entities as far as policy development. So the focus here is to empower that there can be the enactment of legislation to address this commercialization for recreational cannabis, but then to also, in a more simplified version than the version we had before, just say that the focus of this commercialization, the legislation must keep into account that it must be harm reduction, demand reduction, and so forth focused to keep us within that realm that Advocate Roberts also indicated other countries followed to meet both the commercialization demand as well as our international obligation demand to walk that fine line that the focus is harm reduction as well. So Chair, this is a very the simplified version. That brings us more to the point. We have a definition for commercialization here that means an activity relating to cannabis plant cultivation material, cannabis plants, cannabis or cannabis products, which is authorized and regulated by the mentioned future national legislation, and recreational purpose then means cannabis plant cultivation material, cannabis and cannabis products that is used for recreational use, and then future legislation can expand on that. So we're opening the door, but and just like giving some guidelines without being too restrictive. So that, Chair, then is the new proposed clause for commercialization, which I put to the committee for guidance for purposes of publication for inputs, Chair. Thank you.
Members?
Agreed to, Chair.
Any dissension?
Okay.
None. Can you proceed?
Thank you, Chair. Then I'm going to move on to the one that was the religious exemptions. As far as I understood it, Advocate Roberts had some consultation with representatives of the Rastafarian faith, so that informed this proposed revised amendment that our focus is more on the faith-based religious aspects that can also be drawn back to the public participation inputs that we received. Members expressed concerns with regard to the permits and the obligation that would have been placed on Parliament with regard to the approval of such permits, that may go into the realm of a separation of powers. So members will see that this new clause, it's quite lengthy, but most of the length is with regard to the allowing of the giving of reasons and the asking of reasons. So it's the Audi principle that's quite fleshed out in this clause. But it comes down to the fact that authorized representatives will apply to the minister, and the minister will then interact with, or whoever is assisting the minister will interact with them, ask for reasons, ask other interested parties, and so forth. There'll be recommendations asked from the Commission, and the Commission here defines, sorry, Chair, it's quite long. The Commission here defined then is here the Commission of the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities. So inputs will be given as well. It won't just be a consideration of such an application in a vacuum. And the rest of the clause is basically to say that there are form and manner requirements. When must something be done? What must be done? What the application must entail? But to work against that separation of powers infringement, what will happen now in terms of this clause is that Parliament will at certain intervals receive the tabling of what is being done. So Parliament will be kept abreast for reporting purposes. Like here, the Minister must table copies of the permit, the application, and the written reasons for the decision in Parliament before publication of the permit. And this will then empower Parliament to exercise its oversight in terms of the Constitution and the mandate. So what this clause does is with requiring the reporting to Parliament at certain intervals with regard to certain decisions, it helps Parliament to maintain its constitutional mandate of oversight without impeding on the separation of powers and dragging Parliament into the administration, which is not its realm. So, Chair, it looks, this clause looks very intimidating and long, but in actual fact, it's just allowing for all of that and the audience to allow all the affected parties to give their opinions and to allow for reasons and to ask for reasons. So I put this very extensive special measures provision to the committee chair for permission to include this in the public call for opinion on this proposed revised version. It's extensive, but I think that will also aid in giving the public as much information as possible to come back. And then we can always refine it and maybe write it in a more concise version with that input in mind. Thank you, Chair.
Thank you very much, members. Any comment?
Chair, my hand.
Mamujela?
Yes, I think, Chairperson, I hear Ms. Lutz on this one. But in my mind, a question comes, what kind of decisions, just for information, so what kind of decisions that will have to the minister bring to us? Because I'm thinking if they made the community or whoever makes an application and then they sit down and they work on it and then they feel that they are satisfied, at what point where the minister will bring those decisions to the Parliament and report? And what kind of I mean to say, what kind of decisions, just if I may ask, I'm not sure exactly if, but I want something like that, Chair.
Thank you very much. Thank you very much, Honorable Chele. Dr. Lutz?
Thank you, Chair. If I understand Honorable Jelly correctly, is this that where the committee would like there to be an inclusion of, say, the minister must at certain intervals with specific interval indications, or bring something to Parliament, or is the question what the minister must bring? Because if the question is what the minister must table, it's anything with relating to the permit application, and that when that permit application information must be published in the Gazette. If the committee wishes there to be some sort of annual or biannual reporting on this, we can include that, but I would beg some scope to be able to listen to the public submissions to determine the impact of these of these permits before we make a judgment call on how often such reporting should be, so as to empower the committee most as well. So if I can just get guidance from the committee through Chairperson, which aspect of the reporting by the minister is the issue here.
Honorable Chair.
I think, Chair, I did indicate that that's where I get, I needed a clarity, in fact, from Ms. Lutz, in terms of saying which because we are saying the applications, if they make the applications to the minister, there will be a point where they come to the government. So I wanted just to, that is why I said to you, I'm not sure if maybe what I'm asking, I even hear myself, but I wanted to find out at what point, or is there going to be any legislation that we are going to come with in terms of supporting the issue of the application of what. That's why I said, even myself, I'm not even sure exactly what I want there. Thank you, Chair.
So your challenge is on C. The minister must table copies of the permit. Is that where your challenge is?
Yes, to Parliament.
Yes. Dr. Lutz?
Chair, thank you. I think with indulgence, that is where I think public inputs will guide us, because this is very much a clause that came to being out of further consultation. But I think from public submissions, if we put this to the public to get an indication of where the impact will lie from the applications that Honourable Jelle is referring to, we can then craft the relevant application requirements and the publications to notices to Parliament with those specific needs before us. At the moment, this is very much I want to say a clause crafted with very limited information, having identified where there is a need, but we would gain greatly from the benefit from the public submissions in further crafting this to answer those questions that Honourable Jelle has raised, because that exactly is, we don't know where the impact falls yet. And if those communities come and they give a response to this, then we can draft that with the guidance of the committee and with permission, Chair. Thank you.
But that sounds very odd.
Sorry, Chair. The getting the guidance or the asking for publication.
The clause itself, the minister must table copies of the permit, the application and written reasons for their decision in Parliament before publication of the permit in the Gazette.
Is that's the aim behind that is to give Parliament information constantly, so that it is empowered to ask the department the relevant questions if it thinks something is going wrong, or is not being properly processed with the permits and the applications, or if it finds that the reasons being provided isn't sufficient. But that empowers Parliament without placing a responsibility on Parliament to approve permits, which would is the question that the committee previously raised, is that would bring Parliament within the realm of the administration of such permits, which is then a possible infringement on the separation of powers. So the idea of this is so that the committee is constantly updated of the permits, of which applications are received, of the reasons that the minister gives for certain decisions, so that in its oversight, the committee can ask those pertinent questions. And if something in the administration of this act then is wanting, the committee can call on the department to fix that. I think that if maybe just to clarify the intention behind this provision. Thank you, Chair.
No, Honourable Jelle, I would think that for the purposes of publishing, let's allow it to pass, but it's an odd one. I think we will come back and debate it. Because Parliament is inviting to itself an unnecessary administrative burden. Because once those copies have been tabled, then the Speaker will, for Parliament to take a decision, will have to refer it to the committee, to the relevant committee, or an ad hoc committee. It's an unnecessary administrative burden. Dr. Lutz?
Oh, thank you, Chair. Sorry, apologies. Can I continue?
Yes, what do other members say? Must we agree with it for publication purposes now, then you can come back and debate it, or do you want to further debate it now, Christine?
Chair? Oh,
Sorry,
sorry.
Barbara. Barbara, did you want to go?
The Chair, Christine also considered these, so her inputs may be very valuable. I'll await for her response. Thank you, Chair.
Okay. Ms.
I
Singster?
think if we, as the clause stands, it means that the tabling is ready for information purposes. We don't have the power to approve or anything like that. So, but I mean, perhaps we do need to think about what the appropriate role of Parliament would be in all of this. But if we remove it now, then it's not in the published bill, and therefore would be something that we would then need to add in if we then decide at a later stage we want Parliament to have a role. So maybe just leaving the clause in for now. We've given Parliament a role. We're not quite sure whether we want a role or what that role should look like, but at least we've created something around which there can be discussion. If it's not there, then we would be adding it at a later stage, and we wouldn't have the benefit of public input on that particular clause. I don't know if that helps a little bit.
What is the view of other members? Honorable Jelle?
Thank you, Chair. I think she has covered me very well. Thank you, Chair.
Okay, can we proceed now?
Thanks, Chair. My thanks to Christine. I think she more eloquently expressed what I was trying to say. So with great thanks. Thanks to Chair and the committee as well. I will then include this provision for consideration. Chair, then there was also talk of a palliative care provision. The new clause is there. It's to give guidance as to in what circumstances a certified person who requires palliative palliation or suffers from certain severe debilitating physical or mental health conditions may use cannabis for self-medication. It really does give a role for the relevant, as I understand it, the health professionals for their input or regard of this, but also to not to have the person who is using this for palliative care or self-medication reasons in such severe conditions, to also give them some sort of a safeguard. That if they use it, that it's understood within which context they are using it, and that the bill should not be read as obstructing that use. Chair, this is then a new clause that we also would like to put to public comment, just to see if we understand the needs and the framework within which those needs can be addressed within the bill properly. So I put this to the committee, Chair, just for guidance whether we can do so. Thank you.
Members, Honorable Jelle, is it an old hand or a new hand?
It's an old hand, Chair.
Okay.
But if there's no one who maybe would come in, I think I agree with Ms. Lutz. Let's leave this one for the comment, or because she says they've just inserted it now. Thank you.
Okay,
Chair.
thank you. Anyone who disagrees? No, let's proceed. Christine, is your hand up?
Sorry, it's an old hand.
Okay, thank you. Can we
Thank you.
proceed?
Will do so. Thank you, Chair. Then Advocate Roberts has already addressed the class changes with regard to the cultivation of offences. So I won't burden the committee with duplication of what has been previously discussed. I think what is important here is questions were put with regard to how would policing work, and there, a provision has been made for an adult person who transports cannabis in a vehicle on a public road and who contravenes or fails to comply with any condition, restriction, prohibition, or obligation set. So that would allow then for guidance in that area where it comes to such transgressions to be allowed, and regulations to find application. So this bill will not, the intention is that this bill not be read as a hindrance to such aspects. So that was just to maybe allow for the application scope and for guidance in that area to develop without being too restrictive within the scope of this act. With your guidance, thank you, Chair.
Members, can we agree to that for the purposes of public comments?
Yes, Chair. Agreed.
Thank you very much. Let's proceed.
Thank you, Chair. Thank you, members. And then I think it was Honourable Jelly who raised the very pertinent question in previous meetings with regard to imprisonment and offences with the convictions. And unfortunately, in South Africa, we do not have a system yet that allows just fines. So within the realm that we're working in, to allow just fines would be a problem, but the option one was previously presented, but we would like to put option two to the members, where we've dropped the 15 years to 8 years, 6 years to 4 years, just for that aspect. I don't know, I think Christine and I will just have to check if Christine can maybe give me guidance. I'm not sure why 6 months is fine, but I'm not sure why Sorrel made that one 12 years. I think it should also be 2 years. So apologies, Chair, that will change just to align those. But what is new to the members, what we haven't previously put to the committee, is to drop the 10 years to 8 years and the 5 years to 4 years, just to allow for some more leniency. And with permission, Chair, we would like to put those more lenient timelines for conviction to the public for comment. Thank you, Chair.
Which will be option 2.
Yes, Chair. Yes, Chair, with that one adjustment that I think was just a typo.
Thank you very much. The members, option 2 with the correction to the typo. Honorable Jale.
Thank you, Chair. I think let me just agree. Just Chair, a little bit, maybe Chair, when I raised this issue, it was when you were punished by load shedding.
Yes, yes,
yes. Yes, I think yes. My concern on this one was that I know of women who are involved in this issue, chairperson of Cannabis, in terms of commercial purposes. And I know that if it happens that they are found on the wrong side of the law, if you're going to take a single mother with 3 to 4 children in jail for 15 years, for me, it was going to be a problem, especially when they are using this to feed their children and take care of their families. That's how I came up with this issue, but with other reasons, Chair. But I was just concerned with that. But I'm happy with these years that they have taken down. But we'll also continue sensitizing the courts in terms of also considering these issues, because it is, we don't encourage people to be on the wrong side of the law, but we must also think of other issues, that make people to be involved in especially when you come to the family matters, chairperson. We must also be lenient and then have, like I did make a presentation. Thank you, Chair.
Thank you very much. So for now, we are still covered.
Yes, Chair, I'm covered because anyway, it will still go for public participation.
Yes. Thank you very much. Thank you very much.
Thank you, Chair. Thank you, Honourable Members. Sorry, just to correct myself, Chair, I read years and not months, so that is fine. We're dropping 4 years to a proposed 12 months. I think I'm reading double at the moment with all the legislation. So we will then, with permission, then publish option 2 for public comment. And then, Chair, the rest is more or less technical amendments that I think Sarl has previously addressed. This idea with the expungement has also been previously put to the committee, so we did not touch those previously proposed amendments, which we will then include, and some technical amendments with the regulations. All that was added, as far as I could see, was the minister in consultation with cabinet member responsible for health must make regulations to prescribe the form and content of the certificate contemplated, and those are the certificates that we now will be bringing in. So just to empower, that's just an empowering provision. Then, Chair, with regard to the schedules, because we are proposing adjustments to certain levels and quantities, the proposal is, with the committee's permission, then to take those adjustments straight through to the schedules as well, to get public comments. So to take 1 flowering cannabis up to 2 immature cannabis plants, to carry that through to just like adjust the grams and the quantities, and also to put those adjustments that are consequential amendments to the proposed adjustments in the text of the bill to the public, so that we can draw that comparison through and also see how it will impact on the schedules, Chair. I think if I just ask the members for guidance, I'm not scientifically empowered to explain why certain grams or certain plants, but I can say that it has been changed to broaden the scope of the privacy protection as far as use, to allow for that broader area and to accommodate the Constitutional Court's judgment. Thank you, Chair, with your guidance.
Thank you very much. Members, Honourable Taylor.
Chair, thank you very much. I don't think, Chair, we have to touch on this one. Let's just leave it as she was explaining to us. We rely on them to assist us on these issues sometimes. I think let's leave that one as it is, as she has put it. Thank you, Chair.
Thank you very much. Anyone who disagrees? None. Grateful.
Thank you, Chair. And then with those adjusted, like straight through from 4 to 6 and so forth, these are all within the same realm of grams and plants. For that extension, with the permission of the committee chairperson, we would then request a mandate to from the committee for that interim report consideration, which Christine will deal with, and to publish this for comment and guidance from the public due to the expansion of the scope of the bill. Thank you, Chair.
Thank you very much. That report will need to go to the House.
Yes, Chair. Yes, it's an interim report requesting the permission of the House just to expand the scope, because all the clauses that we have in here fall outside the scope of the bill as tabled as per the long title that was provided. So that's just to get our ducks in order for permission for procedural purposes. Thank you, Chair.
So will it mean that we won't invite public comment before we get the permission of the House?
Chair, if the committee can give us that mandate to, from an administrative point, continue with the publication immediately once the House has given that permission, we can do the work in the background and act on the committee's mandate, because we will now only stick to the bill as per this committee meeting discussion and put those choices and those options in this format to the public. So we can, from administrative point, have everything ready to run once that has been given, and it doesn't have to come to the committee again if the committee so gives us a mandate. Thank you, Chair.
Okay. So, Committee Secretary, is it possible that we can get this committee report passed by next week?
Chair, we have just sent the report. It's not a long report, Chair. So we're thinking if it's permissible today, or I was trying to just check if we have quorum, and we do have, we can. But together with the one of the Child Justice Act regulations, we do have them ready. We just sent them. the one on the bill out now, Chair.
Are you sure about the quorum?
Yes, Chair, I've been double checking throughout. We have yourself, Umamo Chele, Ms. Ramulweng, Umamo Utrachen, and Honorable Janki and Mr. Ngola is on the line. So we have 6 members.
Oh, I did not see Honorable Judge. I thought he's gone.
They've rejoined, Chair. We're trying to secure that we've got quorum.
Where is Honorable Ngola?
He's using, he can talk in the meeting.
Chair,
Oh,
I'm around. The problem I have is that my phone just stopped functioning, so I'm using a different gadget that does not belong to me. Otherwise, I'm in.
Oh, no, I'm happy. Can you put the reports, honorable members, both reports, so that at least they can serve before the programming committee tomorrow? I think Honorable Janji would assist us so that maybe by next week, the first available space, the reports are presented to the House. What is the time now? It's 5 to 2. Can I allow 5 minutes for members to read the report, this interim report?
Yes, Chair.
We can start at 2. Ususelani ngoku?
No, I think Christine has raised her hand, Chair, but I was just trying to make sure you see. But let me leave the report.
Yeah, Christine? Christine?
Sorry, when I was muted. When you have the benefit of looking at something after half a day, you see something. So under paragraph 7, I mean, perhaps I should raise this once people had the opportunity to.
Yeah,
There was just some words I want to remove.
Yeah, no, let's first read it before.
Okay, no
yeah.
problem.
Oh. Can we start? Ms. Silkstone?
Yes, Chair. I wanted to remove the reference to the Drugs Act under paragraph 7.
Paragraph 7.
So it should read, the bill as introduced broadly proposes to, and the colon would go there, and then the rest of the sentence would be, rest of that would be deleted. And then obviously the bullet points would go underneath that, like that.
Okay. Any further corrections? Are there corrections on page 1? Let's go to page 1.
Okay. Wilma has a hand up.
Honorable Nivo Trahan.
Thank you very much, Chair. It's not a problem per se, but point 6. The committee held public hearings, blah, 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 but I see no mention of how many.
Sorry, Honorable Nivo Trahan. Let's deal with it page by page. Let's start on page 1.
Okay.
Are there any corrections on page 1? Page 2. Honorable Dragons. Honorable Nivo Dragons.
Mine is on page 3, Chair.
Oh, okay. Page 2. Page 3.
Chair.
Mamuchale.
Number 8, I can't see because the one that I'm having here, it doesn't only have 1 to 2 pages, but if you have that one, it's on, I wanted to comment on point 8. I don't know what page is this, the one that is you have now. What page is that? Yes.
It's page 3 as well, Chair.
Page 3.
Okay.
Am I allowed?
Let's start with Honorable Nivo Dragons and then they will follow. Honorable Nivo Dragons, you raised.
Thank you. Yes, thank you, Chair. So page 3, bullet 6.6. The committee held public hearings, etc., but there's no mention of how many submissions were that the committee received and how many oral submissions as well. I think it's important that it should be included in the report. Thank you, Chair.
Thank you very much. Ms. Silkstone, can that be included?
Yes, Chairperson.
Okay. We will include that. Mamuchale.
Thank you, Chair. On 8, yes. There's where we are saying the Rastafarian faith, where it says provide for the cultivation and then go, okay, I want to go to Cannabis by organization for religious purposes. Organizations, oh, okay. Because, okay, it's fine for religious purposes in adherence to the Rastafarian faith. I'm not sure if maybe, I thought that, but because now of these organizations, I think that one is it, I wanted to find out if it accommodates even other faith formation, Chair. Is it that organization, is it covering the other formation except Rastafarians? Because you'll find that others, they have not yet come out like the Rastafarians, but they use it for the faith purposes. So that organizations, does it cover them? I just wanted to find out clarity, Chair, whilst we are here, all of us. Yes. Thank you.
Christine, is that not fair?
Chairperson, that paragraph 8 is taken directly, the wording is taken almost directly from the amended long title to the bill, and we decided to keep it to that, keep it short and concise and not to go outside of that. And if you look at the new clause that we've added to the bill, it only deals with the Rastafarian faith. It doesn't deal with other religious faiths. The new inserted clause only deals with the Rastafarian faith.
But are we not going to create challenges in the near future?
I'm not too sure if Ms. Lutz is here, but
I'm Chair.
And so Dr. Lutz can also maybe just add to this, but we can always, once we've received public comment on that, we can always expand on that particular clause to be more inclusive. I don't know if Dr. Lutz would agree with me.
Dr. Lutz?
Yeah, thank you, Chair. I think I hear what members are saying and what Christine's saying, so I'll be guided procedurally just by colleagues, but perhaps just hearing what members are saying, perhaps we can just say provide for the cultivation, possession and supply of cannabis plants and cannabis by organizations for religious purposes, and then take out the qualification for now. That will allow the committee some scope within which to decide whether it is necessary to broaden it or keep it to the Rastafarian faith. But then at least, as I understand it, we won't need to go back for permission. So we ask the House for the commercialization, the religious exemptions, and the palliative care. So we keep it to those general areas, and then subsequent to what we get from public submissions, we can craft it around it without having to go back to the House. Thank you, Chair.
So we change the report and then we should go back to the bill because this one has been taken from the bill.
Chair, I don't think we can need to go back to the bill. I think that that provision that the committee just approved for participation will allow us to gauge. As Honourable Jelly now said, there may be groups that just have not come forward yet. The Rastafarian faith, they consulted with Advocate Roberts. So currently that's what we have from the previous consultations. But if any other group comes forward or we get anything from public participation, we can change that. But it's almost the idea of keeping the permission that we're asking general, so that we can fit something specific in the general. But if we keep the request for permission specific, then we can't fit something general in the specific. So rather keep the request area just religious purposes, and then be guided from the responses that we get on the Rastafarian faith clause that is being proposed. So I think the bill as it stands will allow us to gauge that. And if we just keep this then broad, then it gives the committee scope to amend where necessary.
That would not be a good drafting approach to try and to be more accommodative than to just to respond based on the fact that people have come up. Some of them, they might be practicing that faith who are not Rastafarians, and they have no resources. They don't even know that Zoom exists or Parliament even exists.
Yes, Chair, I hear where Chair is coming from. I must admit that the Rastafarian faith consultations I wasn't part of, so I'm relaying what was said. We can generalize that and make it organizations for religious purposes, but then Chair and the committee would have to give us the opportunity to recraft that and come back to the committee before we can go to public hearings on that. The clause that currently stand is, I think, a result of all the information we have had access to date. I don't want to presume that I know anything more about those faith areas than I do. So I'll take guidance from the committee, whether the committee would like us to look at that, recraft it, bring it back for mandate for publication, or to publish as is and then take from there inputs from the community and recraft it with your guidance, Chair.
Members, what is your comment?
Chair, Honorable Wilmer's hand is raised.
Honorable Nico Trachans.
Thank you very much, Chair. And I know I haven't been around, so I have missed quite a bit. I just would like to say that the Rastafari community had a very strong presence and in the public hearings. And yes, there are possibly others who were not represented, but are participating in these aspects that are mentioned in this report. So maybe we can give, we can say we add a comma. So apologies, interpreters, clarifications. So we can leave it as it is, or maybe then add other organizations, the other ones who didn't participate. So we can keep it general and then add a comma and then say or other organizations who did not, or a separate sentence in our request.
Because if we agree to make changes to the report, whether those changes, we should make those changes into the proposed bill before public comment.
Yes, I'm aware, Chair.
Although we are not allowed to look at this, for instance, there is this issue of Rastafari and indigenous communities, which would cover most, then it becomes much more general. How is that, Dr. Lutz?
Chair, I hear the general sentiment being expressed, and that's completely a policy decision. I just don't have the know-how to indicate how that will affect the minister and the administration on that side. That's aspects that the department will have to guide us on. In theory, it's possible to expand. That was there before, and then we took it to the religious specific aspect to narrow it as per previous deliberations. So yes, it is possible. I just can't speak for the department as to how we will have to nudge that to allow for effective implementation and administration. But yes, it should be possible with the department's guidance.
Christine?
Sorry, I hadn't lowered my hand, but I suppose what I would say is that this interim report is to request the House, the purpose is to request the House this permission to extend the subject of the bill. So we're actually asking the House to allow us to extend the subject in terms of allowing for a religious exemption. And it's a case of I think as you've articulated, Chair, it's a case of do we want the bill to be crafted where it's broader, or is it sufficient at this stage, because we've had submissions from the Rastafarian community and they were a very strong presence, to let the bill that is published deal with the Rastafarian community, get the public comments, and also through our deliberations decide that maybe we want to extend it a bit further. But at this stage, Dr. Lutz would have to guide us as to how it would actually impact on the drafting now.
Chairperson, before Dr. Lutz, thank you, Chair. I think subject to correction, Chair, this bill, we are still working on it. Yes, we are still working on it. We are looking at all the loopholes I think I will agree with your view that yes, we might add there. In fact, we must add because we don't want later to find ourselves that we have not completed our work. It's good that the Rastafarians come out clear because they really came forward for this matter. But we are not saying we want to work only for the Rastafarians. The Rastafarians are our indigenous community, but specifically they've been using it bona chair. But I'm sorry, I know people who don't know when I say bona, I'm saying them, they've been using it. Now, let's add on this one because we won't be able to remove this. Let's add on this report that like the Rastafarians and the one that we've just talked about, the indigenous community chair. And then let's go back before we go for public participation. That issue must be included there, or if we don't, it will be left outside. That's my view, Chair, because we can't work for, we are here for even other, we are a voice for other communities that are not able to get, yes. Thank you, Chair.
Thank you very much. There is a hand, Committee Secretariat.
Yes, thanks, Chair. I'm just trying to gather what colleagues and members are saying. So the purpose of the report, as Christine has alluded, is to ask for permission for broadening the scope of the bill. Now, as I've just projected this part, we highlighted red. Why can't we keep the scope in terms of requesting the permission broad? The reason behind that, and not draft the inclusion of other communities, the reason behind that will be that when the bill was published, the Rastafarian, the only faith organization that came on board and took part and strongly was the Rastafarian community. Now, after we have published this bill, if any other organization would come on board as well, in this period we're asking, will come on board and would want to be included, then they would be included. Then the drafting can waiting for their organizations to be included. If we take out the red highlighted part, it will broaden the scope that we are requesting, because now we don't have organizations besides the Rastafarian organization that can assist with the drafting within.
You are cutting.
Can receive the other organization, then we include them in terms of the drafting. That's what I was proposing.
Dr. Lutz, can we include Rastafarian and indigenous communities?
Chair, but I think then rather religious and indigenous communities to broaden it instead of that. But I will have to ask permission if the committee changes it like that, to just get a mandate from the committee whether that clause then will have to be redrafted before public participation. Because then I will have to just request a CR to find out who in the department I can liaise with in Advocate Roberts' absence to not draft something that is not implementable from their departmental administrative side, and then we will have to bring that back to the committee next week with permission, Chair. But I think to cover everything, the report can read.
But Dr. Lutz, a bill is now before Parliament.
Yes, I hear that, Chair.
Yeah, it's not their bill, it's before Parliament. And Parliament would have to process the bill in a manner it deems fit.
I hear that, Chair. I just can't take the argument with regard to the permits any further because I don't have that specific knowledge as to the administrative side of the permits and how that is dealt with. It's quite an extensive clause. I'm merely asking that indulgence because I don't have that direct knowledge that Sarah has on that issue.
I'm talking about the report. What is in the report now?
Yes. That would be, that's for the committee to decide and completely within the committee's mandate. And if the committee wants it to read religious and indigenous religious organizations and indigenous communities, then it's within the committee's power to do so. Thank you, Chair.
Thank you. Is that in order, members?
Yes, Chair, we agree that let's put what you said. Thank you.
Thank you very much. Can I put the reports with all the amendments? Is there anyone who moves for the adoption of the report as amended?
Chair?
I so move, Chair.
Honorable Ngola moves. Any seconder?
I move at a second, Chair. The motion. Thank you.
Honorable Jelle seconds. Can you flag the other report on the sexual offenses? No, child justice. Committee Secretary, can you flag the report on the child justice?
Yes, Chair, I'm on it. It's just the technology is dealing with me. Just a second, Chair. Sorry.
Okay. The report was circulated, I think 2 days ago. It will be taken as read. Are there any corrections on page 1? On page 2, is there a mover for the adoption of the report?
Okay. I move for the adoption of the report.
Honorable Jale moves for the adoption of the report. Is there any seconder?
Seconded, Chair.
Honorable Ngola seconds. The report is duly adopted. Honorable Janji, you would assist us with this report finding their way to the House. Honorable Janji?
Yeah, Chair.
Yes, I'm saying that we are asking you to assist us with this report finding their way to the House.
For when, Chair?
I think it will be next week because I don't think, because the programming committee sits tomorrow.
Okay.
And Friday there's no sitting. But as long as it is with them, the programming committee, if they don't program it this term, but we would have done our work.
Yeah, maybe Sia can just help to forward so that I can tonight check with the programming whip.
Okay, thank you very much. Thank you very much to everybody. Thank you, Dr. Lutz, Christine, the Secretariat. Thank you, honorable members. Thank you to everyone who is on the virtual platform and to those who are watching at home. Thank you very much. The meeting is adjourned.
Thank you.